Letter of credit, which is used in non-side transaction where it serves to reduce the risk of non-performance, is called standby letter of credit. Is a letter of credit a commercial transaction? Is it governed by the NIL? Answer: yes. It is a commercial transaction because it is governed by the Code of Commerce and accompanies a commercial transaction. It is not a negotiable instrument because it is not for a sum certain in money and is not payable to order or to bearer, but is issued in the name of a specified person. ABC Company filed a petition for rehabilitation with the court. An order was issued by the court. Number 1, staying enforcement of all claims, whether money or otherwise, against ABC Company, its guarantors, and sureties not solidarily liable with the company, and 2, prohibiting ABC Company from making payments of its liabilities outstanding as of the date of the filing of the petition. XYZ Company is a holder of an irrevocable standby letter of credit, which was previously procured by ABC Company in favor of XYZ Company to secure performance of certain obligations. In the light of the order issued by the court, can XYZ Company still be able to draw under irrevocable standby letter of credit when due? Explain the nature of letters of credit as a financial device. Letter B. Answer to letter A. Yes, as an exception to a stay or suspension order included in a commencement order issued pursuant to Section 16 Q of the FRIA, Section 18 letter C of the said law provides that a stay or suspension order shall not apply to the enforcement of claims against sureties and other persons solidarily liable with the debtor and third party or accommodation mortgagors, as well as issuers of letters of credit. Similarly, assuming that it has not been superseded by the FRIA, Section 7 letter B of the Supreme Court Rules of Procedure on Corporate Rehabilitation provides that a stay order shall not cover claims against letters of credit and similar security arrangements issued by a third party to secure the payment of the debtor's obligations. This was the basis of the decision in the case of Metropolitan Waterworks and Sewerage System. B. A letter of credit is a financial device developed by merchants as a convenient and relatively safe mode of dealing with sales of goods to satisfy the seemingly irreconcilable interest of the seller who refuses to part with his goods before it is paid, and a buyer who wants to have control of the goods before paying. To break the impasse, the buyer may be required to contract a bank to issue a letter of credit in favor of the seller so that by virtue of the letter of credit, the issuing bank can authorize the seller to draw draft and engage to pay them upon their presentment simultaneously with the tender of documents required by the letter of credit. The buyer and the seller agree on what documents are to be presented for the payment, but ordinarily they are documents of title evidencing or attesting the shipment of the goods to the buyer. Once the credit is established, the seller ships the goods to the buyer and in the process secures the required shipping document or documents of title. To get paid, the seller executes a draft and presents it together with the required documents to the issuing bank. The issuing bank redeems the draft and pays cash to the seller if it finds that the document submitted by the seller conforms with what the letter of credit requires. The bank then obtains possession of the documents upon paying the seller. The transaction is completed when the buyer reimburses the issuing bank and acquires the documents, entitling him to the goods, while the buyer acquired the said documents and control over the goods only after reimbursing the bank. However, letters of credit are also used in non-sale settings where they serve to reduce the risk of non-performance. Generally, letters of credit as non-sale settings have come to be known as standby letters of credit. Number 3. Letters of credit are financial devices in commercial transactions which will ensure that the seller of the goods is sure to be paid when he parts with the goods and the buyer of the goods get control of the goods upon payment. Which statement is most accurate? A. The use of the letter of credit serves to reduce the risk of non-payment of the purchase price in a sale transaction. The letters of credit can only be used exclusively in sales transaction. The letters of credit are issued for the benefit of the seller only. A, B, and C are all correct. Answer B. The use of the letter of credit serves to reduce the risk of non-payment of the purchase price in a sale transaction. Parties to letter of credit. In letters of credit in banking transactions, distinguish the liability of a confirming bank from a notifying bank. In case anything wrong happens to the letter of credit, a confirming bank incurs liability for the amount of the letter of credit, while a notifying bank does not incur any liability. Explain three distinct but intertwined contract relationships that are indispensable in a letter of credit transaction. The three distinct but intertwined contract relationships that are indispensable in a letter of credit transaction are: A. Between the applicant or buyer or importer and beneficiary or seller or exporter. The applicant or buyer or importer is the one who procures the letter of credit and obliges himself to reimburse the issuing bank upon receipt of the documents of the title, while the beneficiary or seller or exporter is the one who is in compliance with the contract of sale, ships the goods to the buyer, and delivers the documents of title and draft to the issuing bank to recover payment for the goods. Their relationship is governed by the contract of sale. Letter B. Between the issuing bank and the beneficiary or seller or exporter. The issuing bank is the one that issues the letter of credit and undertakes to pay the seller upon receipt of the draft and proper documents of title, and to surrender the documents to the buyer upon reimbursement. Their relationship is governed by the terms of the letter of credit issued by the bank. Letter C. Between the issuing bank and the applicant, buyer, or importer. Their relationship is governed by the terms of the application and agreement for the issuance of the letter of credit by the bank. Rights and obligations of parties. Basic principles of letters of credit. Doctrine of independence. A applies with Prime Bank for a letter of credit in the amount of $50,000 in favor of Walmart Trading of California to cover A's importation of 500 bales of cotton. After shipment, Walmart Trading presented all the pertinent documents to Prime Bank's correspondence bank in San Francisco, California, and obtained payment under the letter of credit. Prime Bank now seeks payment from A, who refuses to pay on the ground that Walmart Trading violated certain conditions in their contract of sale and therefore should not have been paid under the letter of credit. Can the bank recover from A? Reason: yes, Prime Bank can recover from A. Banks, in providing financing in international business transactions such as that entered into by A with Prime Bank, do not deal with the property to be exported or shipped to the importer by Walmart Trading, but deal only with documents. The custom in international banking negates any duty on the part of the banks to verify whether what has been described in the letter of credit or draft or shipping documents actually tallies with what is loaded aboard ship. Bank of Philippine Islands versus Dereni Fabric. Number 2. X Corporation entered into a contract with PT Construction Corporation for the latter to construct and build a sugar mill within 6 months. They agreed that in case of delay, PT Construction Corporation will pay X Corporation $100,000 for every day of delay. To ensure payment of the agreed amount of damages, PT secured from Atlantic Bank a confirmed and irrevocable letter of credit, which was accepted by X Corporation in due time. 1 week before the expiration of the 6-month period, PT requested for an extension of time to deliver, claiming that the delay was due to the fault of X Corporation. A controversy as to the cause of delay which involved the workmanship of the building, ensued. The controversy remained unresolved. Despite the controversy, X Corporation presented a claim against Atlantic Bank by executing a draft against the letter of credit. Can Atlantic Bank refuse payment due to the unresolved controversy? Explain. Can X Corporation claim directly from PD Construction Company? Answer. Atlantic Bank cannot refuse to pay because in a letter of credit, where the credit is stipulated as irrevocable, there is a definite undertaking by the issuing bank to pay the beneficiary, provided that the stipulated documents are presented and the conditions of the credit are complied with. Under the independence principle, the issuing bank is not obligated to ascertain compliance by the parties in the main contract. In other words, while the legal relation arises from a letter of credit, such letter of credit contains the entire contract of the parties, and the resulting obligations should be measured by its provisions. It is unaffected by any breach of contract on the part of one of the parties or by any controversy which may arise between them. Letter B. Yes, X Corporation can claim directly from PD Corporation. The call upon the letter of credit is not exclusive. It is merely an alternative remedy in case of delay due to the fault of BT. AAA car makers open an irrevocable letter of credit with BBB Banking Corporation with CCC Cars Corporation as beneficiary. The irrevocable letter of credit was opened to pay for the importation of 10 units of Mercedes-Benz S-Class. Upon arrival of the cars, AAA car makers found out that the cars were all not in running condition and some parts were missing. As a consequence, AAA car makers instructed BBB Banking Corporation not to allow draw down on the letter of credit. Is this legally possible? No, because under the independence principle, conditions for the drawdown on the letters of credit are based only on documents, like shipping documents, and not with the condition of the goods subject of the importation. Number 4. Muebles Clásico, MC, a Manila-based furniture shop, purchased hardwood lumber from Surigao Timber, STI, a Mindanao-based logging company. MC was to pay STI the amount of 5 million for 50 tons of lumber. To pay STI, MC opened a letter of credit with Banco de Plata, BDP. The BDP duly informed STI of the opening of a letter of credit in its favor. In the meantime, MC, which had been undergoing financial reverses, filed a petition for corporate rehabilitation. The Rehabilitation Court issued a stay order to stay the enforcement of all claims against MC. After shipping the lumber, STI went to DBP, presented the shipping documents, and demanded payment of the letter of credit opened in its favor. MC, on the other hand, informed the bank of the stay order and instructed it to deny payment to STI because of the stay order. BDP comes to you for advice. Your best advice is grant STI's claim. The letter of credit is not a claim against the debtor under rehabilitation, but against the bank, which has assumed a solidarity obligation. Fraud exception principle. The Supreme Court has held that fraud is an exception to the independence principle governing letters of credit. Explain this principle and give an example of how fraud can be an exemption. The independence principle posits that the obligations of the parties to a letter of credit are independent of the obligations of the parties to the underlying transaction. Thus, the beneficiary of the letter of credit, which is able to comply with the documentary requirements under the letter of credit, must be paid by the issuing or confirming bank, notwithstanding the existence of a dispute between the parties to the underlying transaction, say a contract of sale of goods where the buyer is not satisfied with the quality of the goods delivered by the seller. The Supreme Court in Transfield, Philippines versus Luzon Hydro Corporation for the first time declared that fraud is an exception to the independence principle. For instance, if the beneficiary fraudulently presents to the issuing or confirming bank documents that contain material facts that, to his knowledge, are untrue, then payment under the letter of credit may be prevented through court injunction. Doctrine of strict compliance. BV agreed to sell to AC, a ship and merchandise broker, 2,500 cubic meters of logs at $27 per cubic meter FOB. After inspecting the logs, CD issued a purchase order. On the arrangements made upon instruction of the consignee, H&T Corporation of Los Angeles, California, the SP Bank of Los Angeles issued an irrevocable letter of credit available at site in favor of BV for the total purchase price of the logs. The letter of credit provided that the draft to be drawn is on SP Bank and that it be accompanied by, among other things, a certification from AC stating that the logs have been approved prior to shipment in accordance with the terms and condition of the purchase order. Before loading on the vessel chartered by AC, the logs were inspected by custom inspectors and representatives of the Bureau of Forestry, who certified to the good condition and exportability of the logs. After the loading was completed, the chief mate of the vessel issued a receipt of the cargo, which stated that the logs are in good condition. However, AC refused to issue the required certification in the letter of credit. Because of the absence of the certification, FE Bank refused to advance payment on the letter of credit. May FE Bank be held liable under the letter of credit? Explain. Number 2. Under the facts stated above, the seller BV argued that FE Bank, by accepting the obligation to notify him that the irrevocable letter of credit, consequently FE Bank is liable under the letter of credit. Is the argument tenable? Explain. No. The letter of credit provides as a condition of certification from AC. Without such certification, there is no obligation on the part of FE Bank to advance payment of the letter of credit. Number 2. No. FE Bank may have confirmed the letter of credit when it notified BV that an irrevocable letter of credit has been transmitted to it on its behalf. But the conditions in the letter of credit must first be complied with, namely, that the draft be accompanied by a certification from AC. Further confirmation of a letter of credit must be expressed. Number 2. At the instance of CCC Corporation, AAA Bank issued an irrevocable letter of credit in favor of BBB Corporation. The terms of the irrevocable letter of credit state that the beneficiary must present certain documents, including a copy of the bill of lading of the importation for the bank to release the funds. BBB Corporation could not find the original copy of the bill of lading, so it instead presented to the bank a Xerox copy of the bill of lading. Would you advise the bank to allow the drawn down on the letter of credit? No, because the rule of strict compliance in commercial transactions involving letter of credit requiring documents set as condition for the release of the fund has to be strictly complied with, or else funds will not be released. Trust Receipts Law. C. Contracted D to renovate his commercial building. D ordered construction materials from E and received delivery thereof. The following day, C went to F Bank to apply for a loan to pay for the construction materials. As security for the loan, C was made to execute a trust receipt. 1 year later, after C failed to pay the balance of the loan, F Bank charged him with violation of the Trust Receipts Law. What is a trust receipt? B. Will the case against C prosper? Answer. A trust receipt is a written or printed document signed by the entrustee in favor of the entrustor containing terms and conditions substantially complying with the provisions of the Trust Receipts Law, whereby the bank as entrustor releases the goods to the possession of the entrustee but retains ownership thereof, while the entrustee may sell the goods and apply the proceeds for the full payment of his liability to the bank. Letter B. No, the case against C will not prosper, since C received the construction materials from E before the trust receipt transaction was entered into. The transaction was a simple loan, with the trust receipt merely as a collateral or security for the loan. This is inconsistent with the trust receipt transaction, where the title to the goods remains with the bank, and the goods are released to the entrustee before the loan is granted. Number 2. Delano Cruz is in default in the payment of his existing loan from DVP Bank. To extend and restructure his loan, Delano agreed to execute a trust receipt in the bank's favor, covering the iron pellets Delano imported from China 1 year earlier. Delano subsequently succeeded in selling the iron pellets to a smelting plant, but the proceeds went to the payment of the separation benefits of his employees, who were laid off as he reduced his operations. When the extended loan period expired without any significant payment from Delano, not even to the extent of the proceeds of the sale of the iron pellets, DBP Bank consulted you on how to proceed against Delano. The bank is contemplating the filing of estafa pursuant to the provisions of PD 115 or Trust Receipt Law to force Delano to turn in at least the proceeds of the sale of the iron pellets. Would you, as bank counsel and as officer of the court, advise the bank to proceed with its contemplated action? I will not advise DBP Bank to file a criminal case for estafa against Delano. Delano received the iron pellets he imported 1 year before the trust receipt was executed, as held by the Supreme Court, where the execution of a trust receipt agreement was made after the goods covered by it had been purchased by and delivered to the entrustee, and the latter, as a consequence, acquired ownership to the goods. The transaction does not involve a trust receipt, but a simple loan, even though the parties denominated the transaction as one of trust receipt. Loan or security feature. X and Company obtained a loan from a local bank in the amount of $500,000, mortgaging as security therefor its real property. Subsequently, the company applied with the same bank for a letter of credit for $200,000 in favor of a foreign bank to cover the importation of machinery. To guarantee payment of the obligation under the letter of credit, the company and its president and treasurer executed a surety agreement in the local bank's favor. The machinery arrived and was received to the company under a trust receipt agreement. As the company defaulted in the payment of its obligation, the bank took possession of the imported machinery. At the same time, it sought to foreclose the mortgaged property and to hold the company as well as its president and treasurer liable under the surety agreement. Did the taking of possession of the machinery by the bank result in the 1. Full payment of the obligation of the company, and 2. Foreclosure of the mortgage? Why? The taking of possession of the machinery by the bank did not result in full payment of the obligations owing from the company and its officers. The taking of such possession must be considered merely as a measure in order to protect or further safeguard the bank's security interest. Dación en pago can only be considered as having taken place when a creditor accepts and appropriates the ownership of goods in payment of a due obligation. The mere taking of possession of mortgage assets does not amount to foreclosure. Foreclosure requires a sale at public auction. The foreclosure, therefore, has not yet been effected. Ownership of the goods, documents, and instruments under the trust receipt. X. A dealer in imported textile opened with Y Bank an irrevocable letter of credit in favor of his American supplier ABC Textile in the amount of $50,000, covering the full invoice value of 200 bales of suiting materials. He paid Y Bank a marginal deposit of $40,000 and the amount of $50,000. The clothing materials were subsequently shipped by ABC Textiles to Manila with Y Bank as co-signee. Y Bank took delivery of the shipment and had it stored in its bodega. Thereafter, X executed the corresponding trust receipt, but before X could take possession of the goods, a fire of unknown origin gutted the bodega of Y Bank, resulting in the total loss of the goods. When sued for the balance of $10,000, X denied liability, contending that Y Bank, as consignee and owner of the goods, should bear the loss. Is the contention of X tenable? Yes, the contention of X is tenable. Y Bank, in said trust receipt, is the entrustor who, according to law, owns or holds absolute title on said goods, and the goods were still in the bodega of Y Bank and not yet actually delivered to the entrustee X, when the goods were totally burned by a fire of unknown origin. Hence, the goods are deemed to be lost for the account of Y Bank. Rights of the entrustor. Validity of the security entrusts against the creditors of the entrustee or innocent purchasers for value. Upon execution of a trust receipt over goods, the party who is obliged to release such goods and who retains security in trust on those goods is called entrustor. Which phrase best completes the statement? In accordance with the trust receipt law, purchasers of the goods from the entrustee will get good title to the goods. Obligation and liability of the entrustee. Who is the entrustee in a trust receipt arrangement? The person to whom goods are delivered for sale and who bears the risk of the loss. Payment, delivery of proceeds of sale or disposition of goods, documents, or instruments. H. Opens a letter of credit with ABC Banking Corporation for the importation of 500 cases of Black Label whiskey with an invoice value of $50,000. The goods and the covering documents arrived, and H would like to take the possession of the 500 cases of whiskey under a trust receipt. The bank agrees to release the goods to him under the trust receipt, subject to the condition that H holds the 500 cases in trust for the bank, and for him to turn over the proceeds of the sale of said whiskey, or to return the goods in the event of their non-sale within 90 days from the date thereof. H sells the 500 cases to various customers, but fails to turn over the proceeds within the period stipulated. Despite repeated demands from ABC Banking Corporation, the bank files an estafa case against H with the City Fiscal of Manila. In his defense, H contends that he should not be held liable because the transaction emanates from a letter of credit, which he claims is civil in nature. He invokes the constitutional provision that no one should be imprisoned for non-payment of indebtedness. If you were the City Fiscal, would you file the case? Yes, I would file the estafa case against H. If I were the City Fiscal, the failure of H and trustee to turn over the proceeds of 500 cases of Black Label whiskey covered by a trust receipt to the extent of the amount of owing to the entrustor within the period stipulated to ABC Banking Corporation entrustor shall constitute the crime of estafa by express statutory provision. The defense of H, therefore, is untenable. Mr. Noble, as the president of ABC Trading Incorporation, executed a trust receipt in favor of BPI Bank to secure the importation of his company of certain goods. After release and sale of the imported goods, the proceeds from the sale were not turned over to BPI. Would BPI be justified in filing a case for estafa against Noble? BPI would be justified in filing a case for estafa under PD 115 against Noble. The fact that the trust receipt issued in favor of a bank instead of a seller to secure the importation of the goods did not preclude the application of the trust receipts law. Under the law, any officer or employee of a corporation responsible for the violation of a trust receipt is subject to the personal liability thereunder. Mr. Noble, as the president of ABC Trading, executed a trust receipt in favor of BPI Bank to secure the importation by his company of certain goods. After release and sale of the imported goods, the proceeds from the sale were not turned over to BPI. Would BPI be justified in filing a case of estafa against Noble? BPI would be justified in filing a case for estafa under PD 115 against Noble. The fact that the trust receipt issued in favor of a bank instead of a seller to secure the importation of the goods did not preclude the application of the trust receipt law. Under the law, any officer or employee of a corporation responsible for the violation of a trust receipt is subject to the personal liability thereunder. A buys good from a foreign supplier using his credit line with the bank to pay for the goods. Upon arrival of the goods at the pier, The bank requires A to sign a trust receipt before A is allowed to take delivery of the goods. The trust receipt contains the usual language. A disposes of the goods and receives payment but does not pay the bank. The bank files a criminal action against A for violation of the trust receipt law. A asserts that the trust receipt is only to secure his death and that a criminal action cannot lie against him because that would be violative of his constitutional right against imprisonment for non-payment of a debt. Is he correct? No. Violation of a trust receipt is criminal, as it is punished as estafa under Article 315 of the RPC. There is a public policy involved, which is to ensure the entrustor with a reimbursement of the amount advanced or the balance thereof for the goods subject of the trust receipt. The execution of the trust receipt or the use thereof promotes the smooth flow of commerce as it helps the importer or buyer of the goods covered thereby. CCC car obtained a loan from B Bank, which fund was used to import 10 units of Mercedes-Benz S-Class vehicles. Upon arrival of the vehicles and before the release of said vehicles to CCC car, the President and Treasurer respectively of CC signed the trust receipt to cover the value of the 10 units of Mercedes-Benz, after which the vehicles were all delivered to the car display room of CCC. Sales of the vehicles were slow, and it took a month to dispose the 10 units. CCC wanted to be in business and to save on various documentations required by the bank, decided that instead of turning over the proceeds of the sales, CCC used the proceeds to buy another 10 units of BMW 3 Series. Is the action of CCC legally justified? No. It is the obligation of CCC as entrustee to receive the proceeds of the sale of the Mercedes class vehicles in trust for B Bank as entrustor and turn over the same to BBB Bank to the extent of the amount owing to the latter or as appears in the trust receipt. Return of goods, documents, or instrument in case of sale. Liability for loss of goods, documents, or instrument. Tom Cruise obtained a loan of $1 million from XYZ Bank to finance his purchase of 5,000 bags of fertilizer. He executed a trust receipt in favor of XYZ Bank over the 5,000 bags of fertilizer. Tom withdrew the 5,000 bags from the warehouse to be transported to Lucena City, where his store was located. On the way, armed robbers took from Tom the 5,000 bags of fertilizer. Tom now claims that his obligation to pay the loan to XYZ Bank is extinguished because the loss was not due to his fault. Is Tom correct? Being the entrustee, the obligation of Tom Cruise to pay XYZ Bank is not extinguished by the loss of the goods. Section 10 of the Trust Receipts Law provides. Section 10. Liability of entrustee for loss. The risk of loss shall be borne by the entrustee. Loss of goods, documents, or instruments which are the subject of a trust receipt, pending their disposition irrespective of whether or not it was due to the fault or negligence of the entrustee, shall not extinguish his obligation to the entrustor for the value thereof. Anton imported perfumes from Taiwan, and these were released to him by the bank under a trust receipt. While the perfumes were in Anton's warehouse, thieves broke in and stole all the item. Who will shoulder the loss of the stolen perfumes? Anton will bear the loss. Penal sanction. Mr. Noble, as the president of ABC Trading, executed a trust receipt in favor of BPI Bank to secure the importation by his company of certain goods. After release, the sale of the imported goods, the proceeds from the sale were not turned over to BPI. Would BPI be justified in filing a case for estafa against Noble? Yes. What acts or omissions are penalized under the trust receipt law? Failure of the entrustee to turn over the proceeds of the sale of the goods, documents or instrument covered by a trust receipt to the extent of the amount owing to the entrustor, or to return the goods, documents, or instruments if they were not sold or disposed of in accordance with the terms of the trust receipt, is penalized as estafa under Article 315 of the Revised Penal Code. Is lack of intent to defraud a bar to the prosecution of these acts or omission? No. There is no requirement to prove intent to defraud. The mere failure to account for or return the goods, documents or instruments in question gives rise to the crime, which is malum prohibitum. E received goods from T for display and sale in E's store. E was to turn over to T the proceeds of any sale and return the ones unsold. To document their agreement, E executed a trust receipt in T's favor, covering the goods. When E failed to turn over the proceeds from the sale of the goods or return the ones unsold despite demand, he was charged in court for estafa. E moved to dismiss on the ground that his liability is only civil. Is he correct? No. Since his breach of trust receipt or agreement subjects him to both civil and criminal liability for estafa. CCC Car obtained a loan from BBB Bank, which fund was used to import 10 units of Mercedes-Benz. Upon arrival of the vehicles and before the release of said vehicles to CCC Car, X and Y, the president and treasurer respectively of CCC, signed the trust receipt to cover the value of the 10 units of Mercedes-Benz. After which, the vehicles were all delivered to the car display room of CCC. Sales of the vehicles were slow and it took a month to dispose the 10 units. CCC wanted to be in the business and to save on various documentations required by the bank, decided that instead of turning over the proceeds of the sales, CCC used the proceeds to buy another 10 units of BMW. Will the corporate officers of CCC be held liable under the circumstances? Yes, particularly the president and the treasurer of CCC who both signed the trust receipt. In the problem, Section 13 of the Trust Receipts Law provides that if the violation or offense is committed by a corporation, partnership, association, or other juridical entity, the penalty provided for in the law shall be imposed upon the directors, officers, employees, or other officials or persons therein responsible for the offense, without prejudice to the civil liabilities arising from the criminal offense. BBB Banking Corporation issued a letter of credit in the amount of $5 million for the purchase of 5 tons of corn by X. Upon arrival of the goods were delivered to the warehouse of X. Thereafter, he was asked to sign a trust receipt covering the goods. When the goods were sold, X did not deliver the proceeds to BBB Banking Corporation, arguing that he will need the fund for the subsequent importation. Is there sufficient basis to sue for criminal action? Yes, because X's failure to turn over the proceeds to the bank is a violation of the trust receipt law. And yes, because violation of trust receipt law is mala prohibita, intention is irrelevant. X secured a loan from BBB Bank to pay for the importation of some dried fruits. Upon arrival of the goods consisting of dried fruits imported by X but before delivery to him, a trust receipt was executed by X to cover the transfer of the dried fruits to his possession. The dried fruits were saleable, but instead of turning over the proceeds of the sale, X used the funds to pay for the medical expenses of his mother, who was sick of cancer of the bone. Which statement is most accurate? X can be held liable criminally under the trust receipt law, regardless of the purpose or intention for the use of the proceeds. X is the president of AAA Products Corporation. X signs all the trust receipts documents for certain importation of the company. In the event of failure to deliver the proceeds of the sale of the goods to the bank, which statement is most accurate? B. For violation of trust receipt law, the law specifically provides for the imposition of penalty upon directors, officers of the corporation. Remedies available. Ricardo mortgaged his fish pond to AC Bank to secure a $1 million loan. In a separate transaction, he opened a letter of credit with the same bank for $500,000 in his favor of HS Bank, a foreign bank, to purchase outboard motors. Likewise, Ricardo executed a surety agreement in favor of AC Bank. The outboard motors arrived and were delivered to Ricardo, but he was not able to pay the purchase price thereof. Can AC Bank take possession of the outboard motors? Why? Can AC Bank also foreclose the mortgage over the fish pond? Explain. A. If what Ricardo executed is a trust receipt, AC Bank can take possession of the outboard motors so that it can exercise its lien and sell them. If what Ricardo executed a surety agreement, AC Bank cannot take possession of the outboard motors because it has no lien on them. Letter B. AC Bank can also foreclose the mortgage over the fish pond if Ricardo fails to pay the loan of $1 million. Policy of the law. Covered institution. Obligations of covered institution. Under the anti-money laundering law, a covered institution is required to maintain a system of verifying the true identity of their clients as well as persons purporting to act on behalf of such clients. The anti-money laundering law is a law that seeks to prevent money laundering activities by providing for more transparency in the Philippine financial system. Hence, the following institutions are covered by the law except casino operators. For purposes of determining violation of the provision of the anti-money laundering law, a transaction is considered as a suspicious transaction with covered institutions, regardless of the amount involved, where which the following circumstances exist. The amount involved is not commensurate with the client's business or financial capacity. There is no underlying legal or trade obligation, purpose, or economic justification. Client is not properly identified. Answer is all of the above. Name at least 5 predicate crimes to money laundering. Answer: kidnapping for ransom under Article 267 of the Act 3815, otherwise known as RPC as amended. Letter B. Sections 3, 4, 5, 6, 7, and 9 of Article 2 of RA 6425 as amended, otherwise known as the Dangerous Drugs Act. Letter C. Section 3, paragraph B, C, E, H, G, and I of RA 3019 as amended, otherwise known as the Anti-Graft and Corrupt Practices. And letter D. Plunder under RA 7080 as amended. And 5. Robbery and extortion under Articles 294, 295, 296, 300, 301, and 302 of the RPC as amended. F. Hueting and Masiao punished as illegal gambling under PD 1602. Piracy on the high seas under the RPC as amended, and PD 532. Qualified theft under Article 310 of the RPC. Swindling under Article 315. Smuggling under Article or RA 455 in 1937. Violations under RA 8792, otherwise known as the Electronic Commerce Act of 2000. Hijacking and other violations under RA 6235, destructive arson and murder, as defined under RPC as amended, including those perpetrated by terrorists against non-combatant persons and similar targets. Fraudulent practices and other violations under RA 8799, otherwise known as SRC of 2000. Felonies or offenses of a similar nature that are punishable under the penal laws of other countries. Under AMLA, a depositor's bank account may be frozen. Choose the correct answer. By the bank when the account is the subject of a suspicious or covered transaction report. By the AMLC when the account belongs to a person already convicted of money laundering. By the RTC upon ex parte motion by the AMLC in a criminal prosecution for money laundering pending before it. By the Court of Appeals motu proprio in an appeal from a judgment of conviction of a criminal charge for money laundering. Answer: none of the above. A foreign delegation of businessmen and investment bankers called on your law firm to discuss the possibility of investing in various projects in the Philippines and wanted your thoughts on certain issues regarding foreign investments in the Philippines. The delegation asked, aside from Filipino citizens, what entities would fall under the definition of Philippine national under FIA 91. You replied that the definition of Philippine national under FIA covers A. Domestic partnership wholly composed of Filipino citizens. Domestic corporations 60% of whose capital stock outstanding and entitled to vote are owned and held by Filipino citizens. Foreign corporations considered as doing business in the Philippines under the Corporation Code, 100% of whose capital stock outstanding and entitled to vote are wholly owned by Filipino citizens. All of the above because the law considers the juridical personality, whether domestic or foreign, as a mere medium. The test of nationality is on the individuals who control the medium. None of the above because the term Philippine national can only cover individuals and not juridical entities. Answer: all of the above because the law considers the juridical personality, whether domestic or foreign, as a mere medium. The test of nationality is on the individuals who control the medium. The delegation heard that foreigners can invest up to 100% of the equity in export-oriented enterprises, and you were asked exactly what the term covers. You replied that an export-oriented enterprise under FIA 91 is an enterprise that. None of the above. Only engages in the export of goods and services and does not sell goods or services to the domestic market, exports consistently at least 40% of its goods or services and sells at least 60% of the rest of the domestic market, exports consistently at least 60% of the goods or services produced and sells at least 40% of the rest of the domestic market, exports consistently at least 60% of its goods or services produced and can sell goods or services to the domestic market. Answer is none of the above. As a last question, and by way of a concrete example, a delegation member finally inquired which of the following corporations or businesses in the Philippines may it invest and up to what extent? Answer: a jeepney manufacturing corporation up to 100% equity, born 2013. But the choices are A. Lifetile Magazine Publication Corporation up to 40% equity, an advertising corporation up to 100% equity, a commercial bank up to 60% equity, a jeepney manufacturing corporation up to 100% equity, a real estate development corporation up to 60% equity. Answer: a jeepney manufacturing corporation up to 100% equity. I don't know the explanation. The main feature of the Foreign Investment Act of 1991 is to introduce the concept of negative lists. Under the said law, what is a negative list? It is a list of business activities or enterprises in the Philippines that foreigners are disqualified to engage in. A foreign delegation of businessmen and investment bankers called on your law firm to discuss the possibilities of investing in various projects in the Philippines and wanted your thoughts on certain issues regarding foreign investment in the Philippines. The delegation has been told about the Foreign Investment Act of 1991, as amended, or FIA 91, and they asked what exactly is the law's essential trust regarding foreign investment in Philippine business and industries. You replied that FIA 91 essentially reflects the foreign investment negative list concept, bar 2013. Embassy Appliance sells home theater components that are designed and customized as entertainment centers for consumers within the medium to high price bracket. Most, if not all, of these packages are sold on installment basis, usually by means of credit cards, allowing a maximum of 36 equal installments. Preferred credit cards of this type are those issued by banks, which regularly hold mall-wide sales blitzes, participated by appliance retailers like Embassy Appliances. The sales clerk who is attending to you simply swipes your credit card on the electronic approval machine, which momentarily prints out your charge slip since you have unlimited credit, tears the slip with the machine, hands the same over to you for your signature, and without more, proceeds to arrange the delivery and installation of your new home theater system. You know you will receive a statement on the credit card purchases from the bank containing an option to pay only a minimum amount, which is usually 1/36 of the total price you were charged for your purchase. Did Embassy Appliance comply with the provisions of the Truth in Lending Act? Answer: there is no need for Embassy Appliance to comply with the Truth in Lending Act. The transaction is not a sale or on installment basis. Embassy Appliance is a seller on cash basis. It is the credit card company which allows the buyer to enjoy the privilege of paying the price on installment basis. Without going into unnecessary details, discuss the legal consequences of a creditor's failure to comply with the Truth in Lending Act, including the effect on the validity or enforceability of the contract or transaction involved. Answer: The failure of a creditor to comply with the Truth in Lending Act would result in the debtor being allowed to recover the interest payment from the creditor, but the validity of the contract or transaction itself is not adversely affected. Dana Giannina purchased on a 36-month installment basis the latest model of the Nissan Sentra sedan car from the Jobel Cars. In addition to the advertised selling price, the latter imposed finance charges consisting of interest, fees, and service charges. It did not, however, submit to Dana a written statement setting forth therein the information required by the Truth in Lending Act. Nevertheless, the conditional deed of sale, which the parties executed, mentioned that the total amount indicated therein included such finance charges. Has there been substantial compliance of the aforesaid Act? No, there was no substantial compliance with the Truth in Lending Act. The law provides that the creditor must make a full disclosure of the credit cost. The statement that the total amount due includes the principal and the finance charges without specifying the amounts due on each portion thereof would be insufficient and unacceptable. If your answer to the foregoing question is in the negative, what is the effect of the violation of the contract? A violation of the Truth in Lending Act will not adversely affect the validity of the contract itself. In the event of a violation of the Act, what remedies may be availed by Dana? The violation of the Truth in Lending Act would allow Dana to refuse payment of financial charges, or if already paid, to recover the same. Dana may also initiate criminal charges against the creditor. True or false? Answer true if the statement is true, or false if the statement is false. Explain your answer in not more than 2 sentences. A loan agreement which provides that the debtor shall pay interest at the rate determined by the bank's branch manager violates the disclosure requirement of the Truth in Lending Act. Answer true. This is contrary to the duty of the creditor to disclose in detail the interest, charges, and other figures indicating in detail the cost of the credit granted to the debtor. XYZ Corporation bought 10 units of Honda Civic from CCC Corporation. ABC Bank granted a loan to XYZ Corporation, which executed a financing agreement which provided for the principal amount, the installment payments, the interest rates, and the due dates. On due dates of the installment payments, XYZ Corporation was asked to pay for some handling charges and other fees which were not mentioned in the financing agreement. Can XYZ Corporation refuse to pay the same? Answer yes, because ABC Bank is required to provide XYZ Corporation not only the amount of the monthly installments but also the details of the finance charges as required by the Truth in Lending Act. The City Fiscal of Manila required the Manila Banking Corporation to produce at the hearing the records of bank deposits of Alfredo Santos. The Manila Banking Corporation refused, alleging that disclosure of bank deposits is prohibited by RA 1405. Threatened with prosecution, the corporation filed an action for declaratory judgment. May the court compel the Manila Banking Corporation to disclose the bank deposits of Alfredo Santos? Answer. Under the law, all deposits with banks are absolutely confidential and may not be inquired into by any government official, except upon written permission of the depositor or in cases of impeachment, or upon order of a competent court in cases of bribery, dereliction of duty, or public officials, or in cases where the money deposited is the subject matter of litigation. Unless the case of Alfredo Santos comes under one of those exemptions, the court cannot compel the Manila Banking Corp to disclose these bank deposits. A bought some goods from a department store and paid with his personal check. When the department store deposited the check of A, the bank dishonored it, on the assumption that the department store did not know who A was. The store manager inquired from the check's jewelry bank the name of the dishonored check. The jewelry bank refused to disclose the name of such jeweler in view of RA 1405, which governs the secrecy of bank deposits. Is the bank justified in not divulging the name of the jeweler to the store manager? Why? Answer. The bank is not justified in not divulging the name of the jeweler to the store manager. The store manager is merely inquiring as to the name of the jeweler of the dishonored check. To divulge the same would not in any way amount to disclosure of any information concerning his deposits, if any, in said bank. Moreover, the inquiry is not an investigation of any balance in favor of the depositor. To include such disclosure within the ambit of the prohibition embodied in RA 1005 would be unduly straining and stretching the meaning of the said Act. The prohibition under Section 2 of RA 1405 concerns merely with the examination, inquiry, or looking into all deposits of whatever nature with banks or banking institution. K borrows $200,000 from Eternity Banking Corporation, which, in accordance with its credit criteria, grants the loan against the security of a plush condominium unit with an appraised value of $1.5 million. ABC Credit Services, a corporation engaged in the gathering of credit information, sends a letter to the bank inquiring about any property of K, which the bank holds, and if any, to furnish the description of the property. Jose Sanos, Vice President of the bank, in his reply thereto, discloses the details of the property mortgaged. Did the bank officer violate any existing legal provision? The bank officer, Jose Sanos, did not violate any existing legal provision. The Republic Act prohibiting disclosure of or inquiry into deposits with any banking institution and the General Banking Act do not prohibit such disclosure on the details of the property mortgage with the bank.